Legal and practical aspects of salvage in the United States. Traditional no cure, no pay salvage of marine property in peril is in slow but steady decline throughout the world. There were 255 Lloyd's Open Form or LOF salvage cases in 1980, but only 107 in 2007. Professional salvors have begun to focus on pollution prevention, which form an increasingly large proportion of their work. In 2007, the International Salvage Union or ISU requested its subcommittee on environmental salvage to form a working group to draft a new edition of LOF focusing on environmental salvage awards, and it called on the Comité Maritime International or CMI to begin drafting a revised salvage convention with particular emphasis on provision concerned with environmental salvage. To some extent, the changing role of professional salvors reflect an increase in the involvement of government bodies in salvage operation, particularly in cases where there is a threat of environmental pollution. That trend is already far advanced in the United States, where the U.S. Coast Guard plays the principal role in handling vessel casualties that involve actual or threatened pollution, with professional salvors often relegated to a consulting position with no direct input into decision making. In a completely different category of case, recreational vessel salvage, salvors gave up using the LOF form in the early 1990s, replacing it with American Standard forms. There is also an active and competitive industry engaged in what is sometimes inaccurately called treasure salvage, the retrieval of property from shipwreck. These three very different categories of case make up a large proportion of the salvage operation conducted in the United States each year, and use of the LOF form is the exception rather than the rule in all three categories. The purpose of this article is to describe the practical and legal context in which salvage operations take place in the United States. Section 2 deals with salvage operation by U.S. military agencies. Section 3 deals with arrangement for civilian salvors to respond to the threat of marine pollution. Section 4 deals with recreational vessel salvage. Section 5 explains what territory is left over for commercial salvage on a traditional contract basis. Section 6 comments on the operation on the Salvage Convention 1989, to which the United States is party, and Section 7 deals with the subject of treasure salvage. Salvage by U.S. military agencies. The U.S. Coast Guard is a branch of the U.S. military. Upon a declaration of war, the Coast Guard operates as a service of the Navy if Congress or the President so directs. In peacetime, it is part of the Department of Homeland Security. Until the 1980s, the U.S. Coast Guard regularly conducted routine salvage operations, including the majority of recreational vessel salvage, which is dealt within Section 4, the frequency of maritime casualties involving pleasure craft led the U.S. Congress to redirect the allocation of the Coast Guard's resources in 1988. The legislation governing Coast Guard operation was amended to require the commandant of the Coast Guard to make full use of all available and qualified resources, including individuals licensed by the Secretary, when rendering aid in non-emergency cases. Since then, the Coast Guard has confined itself principally to emergency cases. Except in cases where there is a threat of environmental harm, the Coast Guard doesn't provide assistance unless there is a threat to the lives of those aboard the vessel, confining its services to those of monitoring the situation. Marine pollution and the threat of environmental harm. The Exxon Valdez disaster of 1989 prompted the U.S. Congress to implement substantial changes to the nation's response to the threat of oil pollution, embodied mainly in the Oil Pollution Act 1990 or OPA 90. Among many other reforms, OPA 90 amended the Federal Water Pollution Control Act or FWPCA to create a National Response Unit at U.S. Coast Guard headquarters in Elizabeth City, North Carolina, and regional Coast Guard District Response Group in each of the 9 Coast Guard districts. This Coast Guard unit provides technical assistance, equipment, and other resources when required by a federal on-scene coordinator, who is the designated federal official charged with implementing the National Contingency Plan or Area Contingency Plan for Pollution Response. The Federal On-Scene Coordinator coordinates all containment, removal and disposal effort and resources and is the point of contact between federal agencies and local responders. The captain of the port or COTP of each of the Coast Guard 46 Marine Safety Office is designated as a federal on-scene coordinator. The National Response Unit must also coordinate the use of private and public personnel and equipment in response to an oil spill or the threat of one. The National Response Unit operates through the National Strike Force Coordination Center or NSFCC at Coast Guard headquarters. The NSFCC maintains 3 strike teams, one for the Atlantic coast, one for the Gulf Coast, and one for the Pacific Coast, which are required by states to maintain personnel who are trained, prepared, and available to carry out the National Oil and Hazardous Substances Pollution Contingency Plan, or NCP, and to keep adequate pollution control equipment and material. The strike team provide rapid response support with experienced personnel and specialized equipment whenever there is a threat of maritime pollution from oil or other hazardous substances. As a consequence, the Coast Guard strike team often perform many of the tasks formerly performed and still performed in some part of the world by professional salvors. The Coast Guard response to an incident threatening pollution may be supplemented by the U.S. Navy, which has statutory authorization to provide equipment and gear to provide salvage facilities to prevent, evade, or minimize damage to the environment from public or private vessels. The Navy Salvage Operation Division being designated as a special team available to federal on-scene coordinators under the NCP. Thus, the Navy may provide assistance in responding to oil or hazardous substance spill or potential spill if requested to do so by the Coast Guard officer acting as federal on-scene coordinator. The U.S. Coast Guard cannot claim to be a salver and so cannot seek salvage reward for performing its obligation under the FWPCA to protect the environment from marine pollution because it is not a volunteer when performing those obligations, which are mandatory. The United States is, however, entitled to recover the actual cost of pollution removal and restoration of natural resources if there has been a discharge of oil or hazardous substance from a vessel. Rather surprisingly, the U.S. Navy can claim to be a salver in similar circumstances. There is specific statutory authorization for the Secretary of the Navy to claim payment for salvage services performed in connection with a marine salvage operation intended to prevent, evade, or minimize damage to the environment. Thank you.